Counsel, can you see and hear me?
Yes, my lord.
Yeah, we had a little hitch from our end here, so we had to reconnect. So please announce, that's Najib Haruna
Yes, my lord. My humble appeal
appearing for,
for the claimant, my lord.
all right.
Thank you, my lord.
Any other legal representation?
My lord, I believe the defendant's counsel isn't in court yet.
Yes, are they aware of today's date? We need
My
to
lord,
confirm.
Maled is in court for the last sitting.
Yes, on the last day I have it on record. That's Chief Magnus Ihejirika. Yes.
yes, my lord.
From the records, the counsel was in court and aware of today's date.
Yes, my lord.
So I shall proceed with the ruling in the circumstance.
As the court pleases, my lord.
Defendants in this suit filed a notice of preliminary objection alongside the statement of defense on 21st day of July 2025, alluding that this suit is incompetent, the claimant having failed to utilize the internal mechanism for dispute resolution before commencing this suit. Hence, this court lacks the requisite jurisdiction to entertain this matter. In support of the notice of preliminary objection is a written address filed on 14th August 2025, wherein learned counsel to defendants raised the sole issue for determination, to wit, whether this suit is not incompetent, this court lacking the jurisdiction to entertain same. Defendant's counsel contends that the suit is incompetent, claimant having failed to exhaust internal dispute resolution mechanisms before approaching the court as stipulated in chapters 8.11, 8.17, 8.21, 26 of Condition of Service 2021. Counsel submitted that a court is competent when there is no feature in the case that prevents the court from exercising its jurisdiction, and case comes before the court initiated by due process of law upon fulfilling any condition precedent to the exercise of jurisdiction, citing AIL 316 Corporation versus Mobil Oil Nigerian PLC. He further submitted that a condition precedent must first be complied with before filing any action in court. Hence, that the claimant respondent has no right of action, having not first exhausted the internal mechanism of the applicant. He cited the case of Onyedebelu versus Nwaneri. In conclusion, counsel submitted that a condition precedent must be strictly complied with, else the court will be stripped of jurisdiction to entertain same. He therefore urged court to so hold and strike out this suit for being incompetent. Claimant's reply on point of law was filed 12 September 2025, wherein the sole issue formulated by defendant was adopted. It was argued that the defendant's contention that claimant failed to exhaust internal dispute resolution mechanism before commencing this suit is unfounded, as the condition of service does not make appeal a condition precedent to instituting an action. It was submitted that the claimant had appealed against his appointment as Assistant Servicom Nodal Staff to the third defendant on 5th May 2025, and the decision to suspend him was subsequently made on 8th May 2025, that the claimant's right to appeal is not an obligation, and the provision does not stand as a pre-action notice or mechanism. Counsel argued that chapters 8.11 and 8.17 of Condition of Service cannot serve as ouster clauses to oust the jurisdiction of the court. The right to access the court is a constitutional right that can only be taken away by the Constitution. He cited in support Udegunam and another versus Onyekonwo and another. Citation is all provided. In conclusion, counsel urged court to dismiss this preliminary objection and allow the suit to proceed. Decision of the court. The notice of preliminary objection filed by defendant challenges competence of this suit on the basis that a condition precedent was not strictly complied with by claimant before filing this action. Issue of the condition precedent in question is the provision of chapter 8.11, 8.17, 8.21, and 8.26 of Condition of Service of Kebbi State Polytechnic, Dakingari, 2021. It is straight law that when a statute or rule of court prescribes a condition precedent to the assumption of jurisdiction, the condition precedent must be fulfilled before there can be vested in the court the requisite jurisdiction to hear and determine the matter. See Aguma versus APC, 2021-14, NWLR Part 1796-351. I should out of necessity state that the effect of non-compliance with a condition precedent for the commencement of a suit is not a mere technical rule of procedure. It goes to the root of the suit and robs the court of its jurisdiction, as held in the case of owners of MV, MSC, Agata versus Nesto, Nigerian PLC, 2014, 1 Nigerian Weekly Law Report, Part 1388, 270 and 290, paragraphs F to G. Now, the very provisions in question are Chapter 8.11, 8.17, 8.21, and 8.26 of Condition of Service of Kebbi State Polytechnic, Dakingari, 2021, which respectively provides thus, I quote, 8.11, every staff has a right of appeal against the decisions of the appropriate authority. 8.17, it shall be an offense for any employee to send any appeal or appeals outside the Polytechnic without first exhausting all internal avenues for seeking redress. 8.21, a petitioner who is still a staff of the Polytechnic shall submit to his immediate superior the original of his petition and such number of copies as will, in addition, provide a copy for each staff through whom it must pass. 8.26, it shall be an offense for any employee to send any petition or petitions outside the Polytechnic without first exhausting all internal avenues for seeking redress, unquote. The courts have severally held that where the words used in a statute, contract, or agreement are clear and unambiguous, the court should give them the ordinary, natural, and literal meaning in order to establish the intention of the lawmaker. It is only where the ordinary or literal meaning of the clear and plain words fail to bring out the intention of the lawmaker or leads to absurdity that resort is had to constructive interpretation. See Dixon versus Silva, 2017, 8th Nigerian Weekly Law Report, Part 1567, page 167 at 233, paragraph D. I've carefully read the entire provisions in question and find that the words used therein are very plain and quite clear without any form of ambiguity. Chapter 8.11 of the Condition of Service cannot mean anything other than that the claimant has been bestowed with the right of appeal exercisable by him against any decision of an appropriate authority which he feels dissatisfied with. What follows then is whether such a right is one which the claimant must exercise before coming to court to ventilate any grievances he may have in that respect. In the case of Odubao versus FSDH Security Limited, 2020, 8th Nigerian Weekly Law Report, Part 1725, 1 at 35 G to H, it was held that in the Latin days of the law, waiver of personal right was encapsulated in the maxim, Quilibet potes renuncia juri pro se introductio, an individual may renounce a law made for his special benefit, unquote. See also the case of Adeagbo and another versus Jinodu, 2022, LPLR 56847, Court of Appeal, page 55, paragraphs A to D. More so, I find that chapter 8.1.7, 8.2.1, and 8.26, read conjunctively, cannot form a condition precedent which must be complied with before instituting an action before a court of law. There is nothing in these provisions that could even remotely suggest a condition precedent which the claimant is required to comply with before commencing this suit and before this court can exercise jurisdiction. It also is incapable of ousting this court from entertaining this matter. Hence, it is my finding that the said provisions forming the crux of this objection are not a condition precedent to the filing of this action, as contended by the defendant. I am in complete agreement with the claimant counsel on his submission in this regard, that these provisions do not form a condition precedent. Thus, the issue is resolved in favor of the claimant, and I so hold.
God pleases.
It is on the strength of the foregoing that I find this objection to be unmeritorious and same is accordingly dismissed. Ruling is hereby entered.
As the court pleases. We are grateful, my lord, for this
You're
sound.
welcome. So we'll give you a date now for, it should be for definite hearing
As the court pleases.
Yes, sir. What date can we suggest to them so that they check them? I suggest the 7th of May. Council, 7th of May.
7th of May.
Yes, check your diary for 7th of May.
It is convenient, my lord.
All right.
Thank you very much, my lord. We are very much grateful.
So case is adjourned to 7th May 2026 for definite hearing.
As the court pleases.
Hearing notice shall be issued and served on defendant's counsel.
As the court pleases.
All right.
We're grateful, my lord. Thank you.
You're welcome, counsel. Yes, Abbas, call the next case.
TN/SP/01/2024 between Dr. Hawa Mukhtar Abdullahi versus Federal Ministry of Education and one another. My lord, the case is for hearing of applications.
Where is okay. Yes, any parties in court?
Yes, my lord, the claimant is in court, my lord.
How about defendant?
Defendant absent, my lord.
Appearances, please.
Whose utmost humility, my noble lord, to M.M. for the claimant applicant.
How about defendants?
Respectfully, my lord.
Yes.
M.N. Muhammad. I humbly announce my appearance for the first defendant respondent.
Fourth.
First, my lord, first.
Okay, one. Okay.
Yes, my lord.
Why is it there is one party on the defendants? How about second defendant? Any legal representation?
My lord, I see him online.
Yes, that's on the last day I had one Isa Ibrahim for second defendant. Isa Ibrahim. Yes.
Yes.
So, and from the records, he was present in court.
My lord, initially before the court started sitting, I saw him online.
Okay.
Now I did.
Yes. So do we give a stand down for just 10 minutes for the counsel, the claimant counsel, the claimant counsel? Are you with me?
Yes, my lord.
Yes. Can we give a stand down just to let the defendant counsel know that the matter is ongoing?
No problem, my lord.
Yes,
As a
because
please.
from the registrar is informing me that he was connected because the court didn't sit at that time that was given. So probably he may not be informed of the time that the court will be sitting subsequently.
As court pleases.
So we'll stand this particular matter down for 10 minutes and get back where we just say, yes, Abbas, are you with me?
the second respondent is calling me now, my lord. Let me
Okay, all right. Is he connected now? Yes, Abbas.
my lord.
Yeah, is he now
My lord.
connected?
Okay, my lord.
Is the second defendant counsel now connected?
No, my lord.
I have one. Who is Memuna? You Sokoto. Okay, that's for Sokoto DVT.
It's our staff, my lord.
Yes, I've seen it. So you said he called you. So is he aware that the matter is now ongoing?
Hello. Hello.
Abbas.
Yes, my lord. He went to receive call.
Yes, okay. He should try to mute when receiving so that it will not. Well,
He's
let him
outside.
mute. Okay, it's outside. All right. Can you give me writing sheets, please? Give me from that side. I want.
Who is this, please?
Yes, Abbas.
Yes, my lord.
Yes.
After I saw his message, I called him. I didn't reach him, my lord. I called him 2 times.
Were you able to reach counsel?
Yes, my lord. I didn't reach. I called him 2 times. Maybe it's from the network, my lord.
Yes, Aliu.
Yes, my lord. My lord.
Yes. Yes.
The
My
second
lord,
defendant counsel just called me now.
Okay.
He said he's having difficulty to connect back. That he's trying, he's making an attempt, but he's having difficulty.
So, do you still want sufficient time to stand down while the court proceeds with number 3 on the course list?
my lord, I'm having case before you, Leonard brother. The
Okay.
even problem we are having with the counsel of the second defendant. My Lord ordered last sitting that we should file everything
Okay,
before
yes.
today. We serve them, but they are filing their counter along with motion for extension of time to file counter. So not even file
No,
their
I
counter
think
affidavit within the time.
what we have here, counsel, what you said they have filed what?
They have filed a motion on notice on 17th February 2026. That is the day before yesterday.
Okay, David, so you are still within time to respond to that?
No, his motion was not even taken. He filed his counter out of time, despite the fact we served him as directed by the court within time. But for the first defendant, he filed his counter. We filed further and better affidavit and reply on funds of law. So we join issues only first defendant. But for the second defendant, he did not file his counter within time. But he has a motion before my Lord today.
Okay, to regularize.
In fact, his motion is not even ripe for hearing.
Oh, okay. So we'll take a date if that's it.
As what pleases, but we'll be asking for cost, my Lord.
We'll just give you a short date since that application is not ripe for hearing.
As what pleases.
Okay, my Lord, it appears he's online now.
The second defendant counsel.
Yes, my Lord.
Okay, all right, that's good.
Yeah, I'm sorry, my Lord. My Lord, our network has issues today. I have to change location.
All right.
Yes. I'm sorry, my Lord. I'm Isa Ibrahim, my Lord. May it please, my Lord.
No. Yes. Yes, sir, counsel.
Okay.
Yes, my Lord. I'm Isa Ibrahim.
The matter is slated today for hearing our application, and we are ready to proceed.
With which application? Which application do you have to proceed with? Which one?
Application filed on 26th January.
When was that application filed? And have you served all the other parties in the action?
We served them.
The application was filed
the first
when?
Defendant we had on 26th January 2026.
And you have served all parties?
Yes, my Lord.
My Lord, the second defendant has a pending application to regularize our response, my Lord.
Yeah, just hold on. He said he has filed an application on 20, but okay, you are now informing court that there's still an application.
My Lord, on behalf of the second defendant, my Lord, we have application to regularize our response to the applicant's application, my Lord.
You are for the second defendant?
Yes, my Lord, for the second defendant, Isa Ibrahim.
So when did you file that application to regularize? What do you want to regularize?
Yes, my Lord, we want to regularize the second respondent written address in opposition to the applicant's application, my Lord. My Lord, the application is dated and filed on the 17th of February 2026, my Lord.
February?
17th of February, my Lord, 2026.
Yes, Aliu and Mohammed.
Yes, my Lord.
You have been served.
Yes, my lord.
Yeah,
Yes,
it's to regularize his written address. Do you intend to counter that?
My lord, we are not objecting.
Okay. How about
but
is it Isa Ibrahim?
my lord,
No,
it's
not Isa
MMILU, my lord.
Ibrahim. Who is the
The
first?
counsel for
Sorry,
the
what's
claimant.
the Aliu? You are for the claimant.
Yes, my lord.
First defendant counsel. I'm so sorry. That's Mohammed.
Yes, my lord.
Yes. Do you intend to file any counter? Can I have your response, please? Because it was filed on 17th. By the rules of court, you are still entitled to a reply. That's counter. That's what I'm asking. Do you intend to file a counter just to regularize? If not, we take that application.
My lord, for the claimant, I think despite the fact the motion is just tested with whereas no.
I can't hear you, please.
My lord, I'm saying, despite the fact we are using the time, the motion is not ripe for hearing. To save our time, and looking at even the motion itself, the proposed counter is not attached, and he has prayer asking this court to deem something which the proposal is not attached to the motion or not.
Not a counter, he's regularizing written address.
Yes, my lord, we are regularizing a written address, and the rules did not state that we must attach same to the application. We have separately filed same.
You are seeking for deeming order and extension of time. Anyway,
Yes,
we have objection. Let him move it so that we save our time.
My lord, we have filed it separately.
So, claimant counsel, do you have any? You are still within time. If we take it that the application is not right for hearing, rather than wasting the time of the court, if you intend to file your counter, you file your counter before the next hearing date.
No problem. My lord, we have no objection. Let him move it.
So we'll give you another date.
My lord, he said he has no objection, my lord.
He said he's objecting to, he was raising some issues. So he cannot raise it orally. So because the application is not right, he's still within time to reply. And since he's raising an issue, then let him come by way of his counter affidavit to that application.
As the court pleases, my lord.
Yes, that is the proper thing to do.
No, my lord, we are waiving our right.
You are waiving your right.
Yes, my lord. Let him move it.
Because he has said he has filed the process separately.
Yes, my lord.
Yes, second defendant counsel, introduce that application, please.
Yes, my lord, we have an application before the court by way of motion or notice. It is dated and filed on the 17th day of February 2026, my lord.
Yes.
My lord, the application is praying for an order of this honorable court.
Yes.
For an extension of time within which the second defendant will file and serve the second respondent written address in opposition to the motion or notice filed by the applicant, my lord.
Yes, so I'll need to cite that that application.
Yes, my lord.
Yes, Barnabas, where is the application?
My lord, my lord, this is the application. They filed it on 17th of this month, that day before yesterday, my lord.
It's not been translated. Yes, Abbas, you have it with you.
Yes, my lord, I have it. They filed it on
Okay.
17th of this month, that day before yesterday. See it there. When you file it, we already send the documents on Monday. So
Okay,
we
you
did
sent it
full.
to us.
Yes, my lord.
So, Abbas, how did you send? You know, normally if it's like this, you ought to have found a way to.
My lord,
Yes, because council is so sorry about that. If I've not cited the application, there's no way I can grant anything on screen this way, virtual, because I've not seen it.
Escort, please.
It's not before me. I
yes,
need
my
to.
lord. They filed it on.
My lord,
They filed it.
we sincerely apologize. We couldn't file the application on time because, my lord, the address we provided for service in Sokoto, when the applicant's application was filed, it was not sent to us immediately. So that was our concern, my lord, and our
So
challenge.
probably that was the concern of claimant's counsel that it is not right for hearing. So we are still going back to objection of claimant's counsel now. That's because now it's not been transmitted to me here. And I need to say I cannot just be granting another when I can't find the process is not before me. I don't think that will be possible. So let's take another date in the circumstance, please.
Escort, please, my lord.
Escort, please.
Yes. Let's take another date. I'm sure within with the process would have reached the Abuja division here. So we can now have a look at the process. Yes.
Escort, please, my lord.
When is the earliest date for Sokoto, please check? March. Okay, we have a date for the 4th of March. So you can check your diaries, counsel. We have a date for 4th of March.
4th March.
So that we can take those applications.
My lord, I'm very sorry. I'm leaving this country on that.
Counsel is an application. You can get another counsel to hold your brief.
What my lord will take us like that. A day before always.
Sorry?
Monday.
What date are you let's allow them to agree on it. Okay.
I'm suggesting.
Yes, counsel.
Monday 2nd or Tuesday 2nd. On that 4th, my lord, I will live in the country, my lord.
Yes. What other dates do we have there? No, look for May. 7th May.
Wow. My lord.
Yes, any
My
date
lord.
in it. Yes, counsel.
Sorry,
counsel, just hold on.
Okay.
I believe what we need to all issues have been joined.
Yes, my lord.
All issues have been joined. Claimant counsel, are you with me?
Yes, my lord.
All issues have been joined. The only thing now is this. I think because I cannot cite this process because you are not in opposition to it, but I need to see the process.
Yes.
I think that's the only
exactly,
issue. So if that's the case and you have joined issues, by the rules of court, even if you are not around, that your address can be adopted on record.
As
even in your absence, the rules permit that. We could have that done and we now adjourn for ruling.
My lord, we have to respond to the written address.
Okay, you have not responded.
That second defendant.
You have not responded.
We are within time. They are just served us the day before yesterday.
So can you look at the date in April? You can get a date in April. Then we take them first if it's just to hear that application. So, counsel, we are looking at a date in April. Yeah, that's I say we take them for. How about 21st April?
It's convenient, my lord.
21, 20, 22nd as well.
It's convenient, my lord. 22nd.
22nd April.
It's convenient,
Yes,
my
my
lord.
lord.
All right. So the case is further adjourned to 22nd day of April 2026 for definite hearing of application. All
As
the
a copy.
applications shall
As
be.
court, please.
So you join issues completely regarding this motion for, is it for mandatory injunction? Yes.
We are grateful, my lord.
So please, counsel in matter, make sure you get connected. I think we'll have to take it by, we have matters for Abuja, I believe, for that day. Yes, so we'll have to take that application first. That should be 9 o'clock, please.
As court, please, my lord.
Take that before the Abuja matters. So the case is adjourned.
As court, please, my lord.
Abbas, you can call the next case, please.
Court, please, my lord. NICN/SK/02/24 between Pad Musa Ahmad versus Medicine Samprontes. My lord, the case is for continuation of hearing, my lord.
Who are the parties in court, please?
No, my lord. The party, the claimant is
Parties are absent.
online. Yes, my lord, I have seen the claimant online.
Yes, when they are online, they are in court because this proceeding is online. This is the court sitting. So
Yes, my
even
lord.
online or physically in court, yes, it's court. Online too is court. So yes, can I have the parties present online? Is that the claimant? Fahad Musa?
Yes.
Yes. Okay,
Yes,
claimant is present. Claimant
Present,
present. Yes. How about defendants? Defendant is absent.
My lord, yes.
Counsel in matter, please. Any counsel?
Yes, my lord.
Please
My name is
announce your
Aliu.
appearance.
My lord.
Yes.
Aliu Jibril. For the
Yes.
claimants.
For claimant, yes. Defendant counsel.
Respectfully, my lord.
Yes,
I,
IB.
yes, my lord, for the defendant.
Yes, counsel.
My Lord, the matter is slated for cross-examination, and we are ready.
IB, are you ready?
Yes, my lord. Subject to the
Okay.
conduct of the court.
Yes, witness.
Yes, my lord.
Yes, that's Fahad. Be reminded that you are still under oath.
Yes, my lord.
I believe that cross-examination. Yes, that's IB. You can proceed, please.
Thank you, my lord. Mr. Fahad, can you hear me, please? Okay.
Yes, I can hear you.
Can you please confirm that you were the HR assistant while you were in the employment of the defendant? Can you please confirm you were the HR assistant?
Yes, I confirm I was HR assistant at Medicine Sans Frontiers Belgium office, KB.
All right. Can you please tell the court what your primary responsibilities were as HR assistant in the employment of the defendant?
Okay. My primary assignment were to execute an administrative and legal related task.
Please hold on, I'm writing. Yes.
Okay, my lord.
Primary assignment
to execute administrative and legal related tasks.
Yes.
Under the supervision of the HR manager.
Yes, counsel. Will that be all?
No, my lord.
No, I'm talking to the witness. Will that be all, Fahad?
Yes, I'm reading from, yes, which includes checking payroll calculations.
Checking what?
Payroll calculations.
The payroll calculation, yes.
And updating personnel files.
All right, thank you. Yes,
yes, my lord.
We have
specifically during a recruitment exercise, what were your primary responsibilities?
During recruitment exercise?
Yes, what were your primary responsibilities?
My primary responsibilities were
take it easy, the court is writing.
Draw up contract.
Your primary responsibility during recruitment exercise entails what? Yes.
During recruitment processes, as national staff employee, I'm not responsible with recruitment, partaking in recruitment process. The only action I take during recruitment process is to send out a reference check after recruitment.
To send out what?
Reference check for employees that are successful. The reference check.
Okay.
And draw up their contract.
Yes, counsel.
Yes, my lord. After your employment was terminated, do you confirm that you received 1,018,970 naira?
1 million what?
Can you hear me, my lord?
Can you repeat that figure?
1,018,970 naira.
Is it 18,000 or what did you say?
Yes, my lord, 1,018,970 naira.
Okay. Yes, so what's the question to
Paid
him now?
to his, does he confirm receipt of that sum paid to his GT Bank account
Okay.
as the full benefits under the contract of employment?
Yes, witness.
Counsel, can you come again with the figure?
1,018,970 naira.
Yes, I confirm to have received that amount of 1,018,000. Yes, 790. Exactly.
Okay. Did you return the money after you received it?
Counsel, can you come again?
Did you return
that money
to the defendant after you received it?
No.
All right.
Yes.
You alleged in your evidence that because of the way you were treated in the defendant's employment, your health deteriorated.
Yes.
And you got the services of a psychiatric hospital.
Exactly.
Do you have a medical report before this court establishing the connection between your work and your health?
I have the medical bills and medical engagement health cards, but as at the time medical report was requested from the hospital.
Not the question. Sorry.
I have
The question
bills
is,
and
do you have a medical report before the court?
No.
Thank you. So basically all we have is your word that your health deteriorated because of work and not a professional's word.
Counsel, can you come again?
I said, so basically all we have is your word that your health deteriorated because of your work and not a medical report from a medical practitioner.
Can you phrase that again, Counsel?
I said, so all we have is your word that your health deteriorated because of work and not a medical report from a medical practitioner.
Counsel, I think he answered you. He said he has no medical reports from the hospital before the court.
All right, thank you, my lord. Please, when was the first time you officially complained to the defendant about your alleged discrimination, victimization, bullying, and harassment?
Yes, witness.
Yes, Counsel. The first time I reported was Are you asking for dates?
If you don't have the dates, you can explain as you can.
Okay, I complained at the time I received a reprimand.
When you received what?
Reprimand letter, saying explanation letter on a certain allegation under review at that time.
Yes.
Which
yes,
of
Counsel.
Yes, I can hear you. Which of, there are many allegations. There are many reprimand letters you received. Which
Yes,
specifically?
during January, I think January, prior to January 9th, 2023.
No, I mean, what was the allegation for which you received the reprimand on?
Pardon?
What was the allegation for which you received a reprimand on?
About recruitment, switching document and engaging employees that were not contracted.
Okay. Was this complaint written?
Yes, witness. Was it a written complaint?
Written, okay, I have it in statement of oath saying that we had a meeting with the HR co. We had a meeting. It wasn't written, but we had a meeting.
Okay, it wasn't
So
written, so it was verbal.
when was the first written complaint?
Yes, witness, when was the first written complaint?
The first meeting complaint. Though there was okay, there was after the explanation letter, I could remember there was a letter of rebuttal I shared, but it was not acknowledged by the HR co. I can vividly remember that.
When was the first written complaint?
The first complaint was first week. Okay, the first written complaint was around when I was provided with the second written in August 2023, when I was provided with the letter for second explanation. That was written. I could remember that was written vividly.
Okay.
I sent an email. That was an email.
Who did you send the email to?
I sent the email directly to the HR co. I copied the project coordinator and other senior team management.
Okay. Can I proceed, my lord?
Yes, go ahead.
Yes. What was the response of the HR co after this written complaint was received?
The response of the HR co.
Yes, please.
Yes. Yes, witness.
Yes, my lord.
Did you hear counsel's question?
No, my lord.
What was the response of
Yes,
the
I may.
HR co?
Yes, I said the response, I can't vividly say because it was through an email, a lengthy email that was shared. I can't vividly remember as I don't have the copy right now. It's in my inbox.
Okay. Were you asked to go on leave after you shared your complaints?
I wasn't asked to go on leave. I applied for leave myself.
And it was granted?
My manager granted leave that I requested.
Okay. Were you paid during this leave?
Pardon?
Were you paid during this leave?
Yeah, I was paid actually. It was a paid leave. I was paid.
Okay.
Yes.
Can I refresh your memory that the HR coordinator's response was to explain the defendant's position? Can you hear me, my lord?
Yes.
Can you hear me?
Yes. Yes, go ahead.
Yes, my lord. So do you remember that the HR coordinator gave a detailed, lengthy explanation on the issues you raised in your complaint, which formed the basis of this suit?
I could remember there was a lengthy mail that was shared, but vividly I can't recall right now because
It's
it's in
okay
the
to
inbox.
remember that email was sent. Did you dispute the facts contained in the HR coordinator's email?
Yes, I did. There was a response from me. I disputed.
Do you remember the content of the dispute, the email in which you sent?
I could remember referencing it on as a subject as psychosocial support and the other brazen acts omitted upon me. But I can't vividly say exact, but I could remember I tried to explain further what she tried to respond from my first email. But I can't vividly say because as it is in my inbox.
All right, no problem.
Yes.
Yes, my lord. In your professional experience and expertise as an HR personnel, what would you say is the purpose of a performance improvement plan?
Okay, well, performance improvement plan mostly is being provided when an employee seems not to be performing in certain areas that need support. And again, it can be used again for retaliation or witch hunting, as HR would use it.
I said in your professional experience, what is the purpose?
The purpose mostly is to terminate an employee.
That is the purpose of a personnel improvement plan.
Yes, in the case we have L&D, learning and development for that, for the purpose of improvement.
Answer the question that I am asking. What is
Right.
in your professional experience and expertise as an HR personnel, what is the purpose of a performance improvement plan?
Performance improvement plan professionally is used
for an employee.
Used an employee when we want to retrench.
Okay.
Yes.
How would you describe an effective performance improvement plan?
An effective performance improvement plan has to be discussed before putting in writing. It has to be agreed between the employer and the employee.
Okay. Is that all?
That's the effective way of administering a PIP, constructive PIP. It has to be
administration. What does it contain?
Okay. It contained gaps.
Okay.
It contained identified gaps. And then parallel this constructive discussion with the line manager, and then ways to support the employee to improve. That's what it contains, supposed in a constructive PIP.
Okay. the targets that were on the PIP issued to you, were they specific targets that clearly outlined areas to work on with clear expectations and timelines?
Well, since the PIP was not implemented, I rejected it because I cannot really say now because the document I did not signed off on it, so I can't really say.
Do you remember reading it?
Reviewing it, I reviewed it once because it was not agreed with me. It was only printed and asked me to sign.
Did you review it? Did you look at it?
I looked at it once because there was no agreement for having a PIP. I was only asked to sign. I meant to say.
No, my question is, did you look at the content?
I looked at it back then when it was issued. That was sometime in October 2023. I can't vividly remember what content it was, but I suppose I should have a copy.
Okay, it's fine. So if you don't remember the content, I suppose you cannot answer that if you had implemented it, what the outcome would have been.
What I'm trying to say, I have the copy. I may have to review because it was only printed. We did not have a meeting to agree on any gap that was identified.
My question is simple. Can you hear me?
Yes, I can hear you.
You said you cannot remember the content.
Vividly,
right?
But I knew.
So I want to confirm, hold on. I want to confirm, since you cannot remember the content, it is fair to also assume that you cannot answer whether what the outcome would have been if you had implemented the targets.
Okay, counsel. I'm saying we should have had a meeting before we have that PIP. That was what I meant to explain.
Yes, IB.
Yes, my lord.
Just to remind you that you had started this cross-examination on the 8th of December.
Yes,
so
my
you
lord.
don't have the whole day. You started at 10:30. Ordinarily, I would have stopped you by now. I can't give you more than 45 minutes. So you have just 15 minutes to round up.
Yes, my lord.
All right.
Do you confirm, Mr. Fahad, that you were presented with an end of contract settlement letter, which you erroneously referred to as a mutual separation agreement, and you refused to sign it?
Yes, I was presented, but I came to the office. I was only represented,
I was not allowed to. Just answer yes or no. Did you or did you not sign it?
I did not sign at the time when it was presented.
That's okay. That's okay.
Yes.
While you were working with the defendant, when a complaint is made about a fellow employee and witnesses are named, is an investigation usually carried out where the witnesses are invited?
Counsel Abe, can you come again with the question? It broke in a point.
When you were working with the defendant,
yes,
when a complaint is made against another employee and witnesses are named, is an investigation carried out where these witnesses are called to state their what they know about the matter? Is it normal practice to ask witnesses to state what they know about complaints?
Complaints?
Yes.
All I know is that HR treats every complaint. That's the only thing I can say.
And if witnesses are named, are the witnesses called to state what they know?
You mean in the practice while working for the defendant?
Yes.
Okay. As I don't handle, I can't really say because I don't handle a code of conduct concerns.
Can you hear me?
Yes, I can hear you.
So
Councillor
you
Adu.
don't know if a witness is named, the witness will be called to state what he knows.
He says he doesn't handle,
I just
or he won't be
no,
handling code of conduct consent.
whether or not he handles, it's a practice in the office. So he either knows or he doesn't know whether or not he handles the.
Are
the
you
H-
putting that across to the court or what, counsel? Is it to the
Sorry,
court?
sorry, my lord. I was just clarifying where the question
Okay,
was
so
coming from.
you clarify it better than that, not
I'm
to
sorry.
ask the court. Yes. Yes, go ahead and ask the witness.
Yes, my lord. Witness,
Councillor
can you
Adu.
hear me? As an
Yes, I
employee
can.
who read the employee staff internal regulations, the code of conduct,
Yes.
and all the other documents signed at the point of your employment, do you confirm that when a witness is named during an investigation of malpractice, the witness is called to give evidence regarding what he knows about the allegation?
Yes, according to the internal regulations as 2021 reviewed, I confirm.
All right, thank you. You mentioned in your evidence that you moved to a new office.
Yeah.
Do you
I'm with you,
confirm
Councillor.
that this office is an extension of the HR office, accessible by a single door?
Can you come again? Because
I said you mentioned that you moved to a new office while you were in the employment of the defendant. Do you confirm that this new office is part of the HR office and there is a single entrance to both the old office and the new office?
I will affirm that that was a store. It's an extension.
But it is an extension.
It was an extension. It was.
That's okay. Do you also confirm that the reason for a move was because the space in the former office was small when a new person was employed?
No.
But you confirm that the move happened after a new person was employed?
Yes.
That's fine. During the period of your employment, were your responsibilities assigned to other employees?
Pardon?
During the period of your employment, were your responsibilities assigned to other employees?
Yes, they were.
Okay.
Yes, counsel, repeat that question.
I was asking if during the period of his employment, his responsibilities were assigned to other employees.
Okay. Yes, counsel, witness.
Yes, my lord.
Or were you given tasks on a daily basis?
Yes.
If I was given tax on a daily basis, no.
Yes.
No, I wasn't given tax on a daily basis. I have my schedule.
So there were stretches when you were not given tasks.
No, I have my schedule already automatically. That's what I'm saying.
Oh, okay. I get that. So you have your schedule and you do the work assigned to you.
I do the work assigned to me.
All right.
However, something.
Yes.
You mentioned in your evidence
Also,
that
you have 5 minutes.
Sorry, my lord, can I just plead for 10 minutes? I won't exceed
I won't
10
give you
minutes.
10 minutes. You had started this cross-examination. I can't give you 1 hour for cross-examination.
I'm sorry, my lord.
Ordinarily, I would have stopped you. So you can't just be asking questions that are not even, if I may say, that are not so relevant. So go straight to the point. It's cross-examination.
I want to point out that
Straight to the point, rather than going into practices of in HR. I don't know how that is very distinct to your to the case. Yes.
Yes, but sorry, my lord, I want to point out that on the last date, I asked just one question, and because of the internet connection, we couldn't continue. So there was nothing done on the last date, my lord.
Even if that were the case, you have now exhausted. I think now you started 10:30, and I think it's now, what time is it now? It's 11:10. So
yes, ma'am.
11:11. So that's almost 42 minutes.
Yes, ma'am. I'll round off now, my lord. Witness.
Yes, counsel.
In the two instances where you were issued written warnings, do you confirm that the incidents for which you were issued written warnings for actually occurred?
No.
Did the incidents occur where people employed, given offer letters for positions they were not employed for, were names substituted? Did the incident occur? Not whether you did the error. Did the incidents occur?
It did occur. Yes.
They did occur.
Yes.
Okay, good. And you were a part of the recruitment exercise, am I correct? Did you hear me? Were you a part of the recruitment exercise?
Well, no.
You were not at all a part of the recruitment exercise.
No, I was not part. I was not part in interviewing. No, the national staff don't.
Interviewing in the overall recruitment exercise, were you a part of it?
No.
Okay. Whose duty was it to contact successful candidates?
Yes, my duty. Yes, it's my duty to contact.
So you would agree that if wrong candidates were contacted, it was your responsibility to contact successful candidates. It was okay to ask where the error happened, since it was your duty to contact successful candidates.
No, contacting happened through instruction by a line manager.
Was it your duty to contact successful candidates?
Not all positions, some positions, not all.
All right. In the case where you were issued warning, was it your duty?
No, it wasn't.
Okay. Were you ever explicitly told after you were issued a warning that you have been found innocent of the accusations? Was it ever explicitly told? Were you ever explicitly told?
Yes, it was stated in my response letter.
In your
my warning
response
letter. Well, that's warning letter.
That you are innocent.
That I did not breach any of the code of conduct or internal regulations.
So you clarify that what is stated in that letter is that you did not breach the code of conduct.
That was what was stated.
Okay. In the second incident, can you hear me?
Yes, I can hear you.
Yes, in the second incident, where the encoding was done wrong, you mentioned in your evidence that after you explained how the error happened, no further action was taken. Is this correct?
Yes, I was not responded to the my response. There was no response.
So you were not disciplined, you were not punished.
I was not disciplined, but I was retaliated upon.
Was there an official letter stating that you have been disciplined or punished?
No, I presented my response to the warning letter. I mean explanation letter, but nothing. They didn't say nothing to me. But later to come to say they give me PIP.
So there was no official discipline.
That was not official, but there was PIP immediately.
Can I continue, my lord?
You have just 5 minutes, and I will stop you. I will
Thank you.
stop you. Whether you finish or not, I will stop you. All right.
No, my lord,
I will stop you as soon as it's 5 minutes, Council. So you note
yes.
that. All right.
Yes,
As soon as it's time.
To take your mind back, when you were called to give evidence, as you stated in your evidence that you were called to give evidence against an expatriate.
Yes.
Can you hear me?
I can hear you.
Did
I can hear you.
Was it explained to you why you were called to give evidence against the expatriate?
I was told that he was under sexual exploitation code of conduct, and which I knew nothing about. I'm a national staff. I don't meddle with IMS, International Military Staff.
And you said this to the HR coordinator?
I told her that I knew nothing about it.
That's fine. After the meeting, was there a formal notice letter given to you stating that you were being punished for your response during the meeting?
There was a letter, but there are different ways in HR to do things.
Please answer the question. Were you given a formal notice complaining, berating, or punishing you for your response during the meeting? A formal notice?
There was no correspondence formally.
Okay, but you confirm that it was the situation was there was an allegation against a staff and you were called to give evidence.
Yes, I was told there was allegation. Yes.
All right, thank you.
Yes.
Yes, my lord. You mentioned in your evidence that you moved to a new office. Do you confirm that the reason for the move to the new office was because you wanted more space to do your work?
No.
You informed the HR manager.
No, I don't agree with this statement.
You don't agree?
Yes, that was not the case.
All right.
Yes, please.
Yes, my lord. That will be all for the witness, my lord.
Yes, claimant's counsel, please. Claimant's counsel.
No examination, re-examination, my lord.
No re-examination. Yes, will that be all for the witness and the case
Okay,
of the claimant?
case of the claimant, my lord. We humbly apply that the the claimant be discharged, the witness EW1 be discharged.
Okay. Yes, the witness is hereby discharged. Yes. And now the case of the claimant, I believe, is closed at this juncture. Okay. Yes, defendant counsel.
Yes, my lord. We'll be asking for a date to get our witness ready for to open our defense.
Yes, let's have the time to check it. What date?
7th of May.
Yes, 7th of May.
It's convenient, my lord.
Yes, claimant counsel.
7th of May.
Yes.
Convenient, my lord.
All right. So upon agreement of counsel, case is further adjourned the 7th day of May 2025 for continuation of trial and for the defendant to open
Escort,
defense.
please.
So defendant counsel to prepare witness.
Escort, please.
No,
2026, sorry, not 2025.
Escort,
7th May 2026.
Escort, please.
So that should be all regarding this matter, and equally ends the cases for today as per the court list.
Thank you.
Right. Thank you, counsel.
Wish my lord a very happy days.
Thank you.
Ahead.
Yes, thank you, Aigbe. You can now exit the platform, and equally the registrar. Thank you, Abbas.
God bless, my lord. Thank
All right.
you, madam.
Okay.
Thank you, my lord.
All right, Aigbe. Yes.